Thank you, Chief Justice. Good evening, Judge Aoyo.
Good evening.
There are comments from law bodies, and I'm quite sure that you saw the comment from the Black Lives Association.
Yes, I did.
And in response to that, you withdrew or you resigned from the South African Board of Deputies.
Yes.
So, but the comment of the Black Lives Association in that regard went further and indicated that his affiliation as defined above might even go as far as to put into question his sense of justice.
Yes.
I want to talk to that, taking into account the views we have as the country in respect of the relationship between Palestine and Israel.
Yes, well, let me firstly explain what the Jewish Board of Deputies is, and then I'll explain why I resigned responsively to what the Black Lawyers Association had to say. I was asked in the course of last year, when we were in the middle of a pandemic, to come onto the board. You should understand that the Jewish Board of Deputies is concerned with the welfare of the Jewish community. And by welfare, it is concerned with old age homes, burial societies. It's concerned with people who've fallen on hard times more generally, but particularly now in the pandemic, and assisting other communities where there is need and hardship. So the Jewish Board of Deputies is a community organization concerned with Jewish welfare and the welfare of other communities within the country. And its other concern is about anti-Semitism and preventing anti-Semitism. It is not a body that is concerned to promote Zionism. The Jewish Board of Deputies is a body that has existed for well in excess of 100 years, and indeed its precursor organizations for many, many decades before that. And so I went onto it because it seemed to me to be about assisting, to the extent I could, with welfare issues for communities in sometimes very dire need. And I don't therefore think that it is concerned with to promote Zionism. There are other organizations that do so, but I have no affiliation or connection to them. But I did think that when the Black Lawyers Association raised the point, they'd raised an issue which I did need to think about, and it's this, that from time to time, the Jewish Board of Deputies engages in litigation against hate speech concerning anti-Semitism. And on occasion, those matters have even gone to the Constitutional Court. And it did seem to me that in those circumstances, if I was going to offer myself as a candidate for judicial office in the Constitutional Court, it would be appropriate to step away from that organization because it does have this role. And whatever I might have been able to do by way of assisting welfare efforts in a time of great need must perhaps yield to the perception that one shouldn't be connected to a body that is engaged in litigation. So I did step down, and I've circulated my letter of resignation, but I don't think that my connection in accepting a position with the Jewish Board of Deputies is one that impacts and is connected to Israel and the Palestinian and Israeli conflict, which is an entirely separate matter.
If that is the position, why then did you resign before you could hear the outcome of these interviews? Because if it is a welfare organization and which you resigned because you don't want to be sitting at the Constitutional Court if and when they litigate, why wouldn't you wait for your appointment and do that? And if the concerns of BLA were of no concern to you regarding Zionism?
Well, as I say, I don't say that the BLA's concerns were of no concern to me. They were concerned to me for a reason different from the one that the BLA raised. And I did so in stepping down because it seemed to me that whether I'm ultimately recommended for office in the Constitutional Court or not, the question of a body that does litigate over questions of anti-Semitism and hate speech and the like, perhaps it would be better for a judge not to be part of that organization, whether on the Constitutional Court or otherwise. I mean, obviously, one could always recuse oneself and the like, but perceptions sometimes matter. And I think once the issue was raised, I gave it thought, and that seemed to me to be ultimately the wisest position to take.
CJ, if you may allow me, when CJ indicated to you that you may indicate where you come from, including bragging, one of the things that you said and agreed with the CJ is that you went to one of the finest universities in the world.
Yes.
I want you to assure us if that does not go with white privilege, that you are able to be in that position, and how will that assist the communities that you are going to adjudicate if you go to the Constitutional Court?
I think it's indisputable that I had privilege and that was connected to a state of affairs in this country where white people were advantaged at the great expense of the great majority of people without any question whatsoever. I think the fundamental issue is, what do you do with the privileges that you've had? Do you seek to give back? Do you seek to use such advantages as you've had to try and build a better society than the one that certainly I grew up in? Or do you simply luxuriate in your privilege and simply parade it to no advantage other than your own? I take the former position, and that's what I've tried to do.
Finally,
Honourable Commissioner, you remember we have the power outage challenge and to speak to questions.
Yeah, CJ, I can forego this. I believe other commissioners will cover it. Thank you.
Thank you, sir. Thank you very much. Honourable Magwanisha.
Thank you very much, CJ, and good evening, Judge. In the interest of time, I only have one question. How many African lawyers and women in particular did you empower in the area of trade law when you were still practicing as an advocate, especially as a senior counsel? And in what specific way did you empower them?
Well, I can't say that in respect of trade law, I did terribly much by way of practice in South Africa. Most of my work in international trade was done outside of the country. But I certainly can say with absolute assurance that in my practice as a whole, I have worked extensively with Black counsel and with women. And there are many leading Black counsel today who were juniors with me over many, many years. And it's a source of great pride that I have, that we work together in such a collaborative way that I have made some contribution to the development of their practices. So trade law is not an area that I have done much practice in. I can say, however, though, that throughout my period of time in practice, I taught at firstly the University of the Witwatersrand and thereafter at the University of Cape Town. And there are generations of students who passed through my classes, both in competition law and trade law, significant numbers of whom are Black and women, and some of whom have gone on to significant achievements in the field.
Judge, you did receive quite a few cases from the Department of Trade and Industry.
Yes.
On the area. That is why I'm asking this specific question.
Yes. I think that's absolutely correct. That there were, I think I got really my first break in trade law, frankly, when an assistant to the Director General briefed me in quite a big case called Brenco. And my junior in that case was a woman, Janet Kentridge, who no longer practices in South Africa. But we worked together on that case, and that was my first introduction to trade law. Thereafter, I worked not terribly much with juniors, but certainly with attorneys, where black people, black lawyers constituted part of the team. And we worked very closely together. So although it's true that the greater amount of my work in trade law was probably done outside of the country rather than in it, even the work that I did do here had significant involvements of black lawyers with me.
Thank you very much, Chief Justice, and thank you, Judge.
Thank you, Honorable Magwanishe. Honorable Minister.
Yeah, thank you very much, CJ and Judge. On this question from Councillor Skogo, don't you think that your affiliation or being a former or ex-leader of the Jewish Board of Deputies may raise these possibilities of bias when issues related to the state of Israel or Palestine arise in our court?
Minister, I don't think so. And I don't think so for the reason I've already given, which is that the Jewish community, which has been long established in this country for centuries in different forms, it's made up of people with very, very different attitudes to the state of Israel and indeed to the state of the conflict between Israel and Palestine. So there's nothing about being on the Jewish Board of Deputies which would lead, in my view, to a perception that I would have any bias in favor of Israel in respect of a legal issue that might arise in a case that somehow trenched upon the conflict that exists in that part of the world. But if a case were brought and it could be shown that somehow or another my position for, I don't know what it has been, 9 months, I suppose, on the Jewish Board of Deputies somehow or another is implicated in the litigation, then as with any other case, I would look at the merits and have to decide whether I should recuse myself. But I can't see, given what the Jewish Board of Deputies does and what its constitution requires it to do, that there is any linkage to the Israeli-Palestinian conflict.
Yeah. On your role, Judge, as in the appellate body of the World Trade Organization,
yes,
are you able to tell us judgments that you believe contributed in terms of developing for the developing world, given the situation we currently face in the world, where we're speaking about the vaccine nationalism and the role of that body for the distribution of the vaccine and various medication and IPs? Do you think that experience, or there's any role you think you played in that court, or that experience will be helpful for you in our court?
I do think so. One of the key features of the WTO system.
Yeah, maybe on the same question will be, last one on that one will be, do you also think that we may need the same kind of arrangement, given that we now have the Africa Free Trade Agreement?
Yes.
Yeah.
Well, let me answer both questions in one go. The key feature of the World Trade Organization is that it is an organization of rules. And the importance of those rules means that Smaller countries, mid-sized economies and smaller, can have the benefit of those rules, which are of general application to all members. It's a feature of international rule of law, which can be extremely advantageous to developing countries because they have remedies in their trade relationships with much larger economies that allow for outcomes that can be highly advantageous to their ability to engage in trade across the world. And among the happy features of what I observed when I was deciding cases with colleagues on the appellate body is the effectiveness of many developing countries in utilizing the WTO system to their economic advantage. So countries, for example, like Brazil and countries like Mexico and China used the system in order to pursue their trade interests through a body of rules that was enforceable at an international level with sanctions that could follow upon breaches of the rules. So I think that I not only learned the value of a rule-based order, which sometimes can exist nationally, but in this instance existed and exists supranationally, but also the opportunities that it entails for developing countries in seeking to pursue their interests through bodies like the WTO. To come to your second question, one of the features that I would suggest is that there is a very close relationship between the building of an African trade community, which is a great and important experiment that we are about to begin that journey in Africa. Because one of the key features of many of our economic relationships is that they still bear the imprint of colonial trade relationships. Many African economies have stronger economic relationships with their erstwhile colonial masters than they do as far as intercontinental trade is concerned, and that needs to be redressed. And that's partly what building the African community is intended to do. It's an ambitious and hugely important project, but it needs to fit together with a global system as well. Because although it can facilitate trade as between members within Africa, African countries, our own included, have very important trade connections which remain with the rest of the world as well. And so it doesn't suffice to simply improve trade across the continent between African countries. One needs to get access across the world. And these two things are interconnected. They're not either or situations. And just to touch on lastly, the question of what vaccine nationalism illustrates for us. It shows how in situations of emergency, countries often go back to their national interest for perhaps understandable reasons. But it pinpoints the fact that at so many levels, interconnection between countries matters critically to advancing their economic and social, and indeed in this case, health interests. And sometimes that requires cooperation, and sometimes it requires even litigation around, for example, intellectual property rights, and where there may or may not need to be waivers under the relevant trade agreements that exist. So these interests are critical, they impact on countries, and I think my short answer, Minister, is to say we need to be an important player both in the African community but also in the global community.
With your indulgence, CJ, I request to ask one last question.
Go ahead, Minister.
Yeah, given the white privilege you spoke about earlier, that indeed you have been privileged in this country, do you think it will be fair to appoint you to the court when you have never acted in that court? And there are black practitioners who have been judges of the Supreme Court of Appeal for many years than you, and also the High Court, and some of them have also acted at the Concord, and most of it was almost a sacrifice. Will it be fair that you were still busy with practice, and I would assume you'll have also made lots of money through your practice?
Well, I think it's less a question of fairness and more a question for this body to work out how I might be of assistance in serving the Constitutional Court. People come to sit in the position I do here before you through different pathways. Not everyone pursues them in exactly the same way. I, of course, accept that it would be useful to have acted in the Constitutional Court, but one can't do absolutely everything in every dimension over one lifetime and still say that you tick every single box for every single purpose. As I sought to indicate, I didn't just spend time at the bar having a lucrative career. I devoted time and attention to other things that I think gave back. And as I say, I spent 8 years on the appellate body, which is in service to, I think, a concept of the international rule of law. And so I accept that, you know, I could have gone a different route. I could have gone to the bench earlier, perhaps, and not gone to the WTO. And that might have put me in a position to have had the privilege of acting in the Constitutional Court. As I say, I think ultimately it's for you to decide whether the experience that I've had and the attributes that you may think that I can lend to the efforts of the court are ones that are useful to the court. I don't think it's simply a question of who has gone through a singular set of experiences to be of greatest help in constituting the court. And I would just make one last observation, which is that the strongest courts are courts that harness the best talents of the country. At the end of the day, as I've sought to indicate, we want to be ambitious about the Constitutional Court. We want it not just to reflect the country, which the Constitution requires, but also to harness the talents and energies of our best lawyers so that it can be an authoritative court of great repute. If I can be of some assistance in that project, that's the only basis I offer myself to you.
Thank you, CJ.
Thank you, Minister. Commissioner Tsepe.
Thank you, CJ. I have two questions for Justice Unterhalter. Good evening, Justice Unterhalter.
Good evening.
Welcome. Justice Unterhalter, as you know, the Constitution requires courts when interpreting any legislation, when developing the common law and customary law, to promote the spirit, purport, and object of the Bill of Rights. What has been your experience in specialist courts or when dealing with commercial matters to the observance by judges of this constitutional obligation? And if you could point to cases that you wrote that reflects your observance of this important constitutional obligation.
Yes, I think that by and large, it is well appreciated in the courts that the supremacy of the Constitution requires that it's the rights that are recognized under the Constitution and ultimately its values are the bedrock of our legal system and are pervasive. How that then works in terms of interpretive problems that come before the courts can play itself out in different ways. But I do think that it's clear that courts understand this question of supremacy, and they do understand that although many lawyers schooled in the common law as it has existed pre the Constitution need to think again about how the common law is to be understood and conceptualized in the light of the clear constitutional injunction that takes place. Now, that is a process of steady development. It's not something that is just announced overnight, but I do think that in all courts, there is a very clear recognition of this. Let me illustrate a case that I was involved in, where I paid particular attention to this problem. There was a case that was brought by an applicant who came to court to say that certain banks had been involved in collusive trading on certain commodity exchanges in Chicago in the United States. And they had been sanctioned by the authorities in the United States. And the contention that was made in that case, I've cited it for you, called a SHUCO, was whether that did not infringe the right to food security in South Africa, because some of these future transactions in commodities, including maize, which is a staple product, could impact upon food security in South Africa. And the first question that arose in that case was, did a South African court have any jurisdiction over a regulatory violation that had occurred in the United States in respect of trading on the Chicago futures exchanges? And in the case, you'll see that I took the view that if it is the case that a wrong that is committed outside of the country, which has effects in the country that are potential violations of the Constitution, then that is jurisdictionally competent for a South African court to entertain. And in taking that objective conception of jurisdiction, I did so under the guidance of the reach that our Constitution is meant to have. I could have taken a different view, a much more restrictive view, and said, that's for America. The US courts and regulatory authorities have determined that matter. We shouldn't go anywhere near this case. But I allowed for the possibility that we could. I found ultimately on the facts that there wasn't an effect of the kind that was complained about, but the jurisdictional perspective was an expansive one, guided by the values of the Constitution.
Thank you, Justice Unterhalter. Just to my second question. The Constitutional Court has, in a number of its cases, in my view, competently dealt with matters of international trade and competition law, which are some of the areas in which you have expertise. Should the Commission view your expertise in these areas as a distinct advantage in considering your application in view of its competence in dealing with some of these matters, or how it has dealt with these matters in the past?
Well, it does appear to be the case that a not insignificant number of competition law cases are finding their way to the Constitutional Court from the Competition Appeal Court. And for that reason, I think it might be advantageous to have on the Constitutional Court someone who has spent a lot of time in the field. The Constitutional Court has dealt with these cases, and some of them are I think, difficult cases. But I think it might be of some assistance to allow a judge who has had some background in this area to be on the court. And similarly with international trade, these are relatively abstruse areas, perhaps not so much competition law nowadays, but certainly international trade. And international economic law as a more general area is one that I would certainly have some experience in, and it could be of some assistance to enrich the court. As I've said already, the importance of the court is that it harnesses many talents from many quarters. No one has a monopoly on all of those talents. There are some things that I hope I could bring to some advantage for the assistance of the court, if I were appointed.
Thank you, Chief Justice. Thank you, Judge Unterhalter.
Thank you, Commissioner Tsepe. Thank you, Prof.
Thank you, Chief Justice. Good evening,
Good evening.
Judge Unterhalter. I must perhaps say that I know Judge Unterhalter. We've worked together at WITS in international trade law. He sometimes gives guest lectures also to the students still. Judge Unterhalter, what I would like to know from you is, as academics, we've noted over the many years that the depth of judgments, the scholarliness of judgments have kind of deteriorated. And in a system of law which is uncodified, this is quite alarming. What is your take on the matter?
Well, I think one has to understand how judgments come about. Almost every court is under huge pressure, and not every case can result in an account of the law that certainly from the perspective of academics would be thought of as rigorous in every single way. Speaking for myself, what I like to do is to look when there's a case that seems to have specific novelty or complexity, to take the time to research the sources, look carefully at the arguments that have been made. One does that in every case, but to try to invest the judgment with, perhaps you might not say scholarly insights, but at least with a consciousness of the gravity and complexity sometimes that cases throw up. So I think the criticism is in part correct and in part not correct. The part that I think one needs to understand and give some latitude about is that the system just doesn't permit every judgment to be scholarly in its approach, but it must be effective, it must be well reasoned, and it must speak to the parties and the issues that they've brought. But there are occasions where we do want our case law to be reflective of judgments which, from an academic perspective, it causes academics to say this is a judgment of great interest. Whether they agree with it or not is a separate question. I think we still produce those judgments. I think the only issue we may have is whether we produce enough of them. And I think that is partly a function of the volume of cases and the pressure of judgment, of getting out judgments. It's a huge priority that the litigants who bring the cases are entitled to not just a well-reasoned and carefully thought through judgment, but to an answer that comes relatively quickly. And one has to balance these things up. So I think your point is well made, but I have obviously a huge respect and regard for academia and the academy and what it does. I just hope that the diet is not too thin for the academic endeavors that academic lawyers engage in. I don't think it is, but perhaps it could be a little richer.
Thank you, CJ.
Thank you, Prof. Commissioner Madonsela.
Thank you, Chief Justice. Good evening, Judge Unterhalter.
Good evening.
The first question that I would like to ask you has a premise, and please, when you answer the question, correct me if I'm wrong in the premise upon which I based my question. I understand the role of a appellate court, amongst other things, to be to afford litigants a broad spectrum of minds to consider the matter brought before it from a lower court, so that litigants have a benefit of many people thinking about the matter and making a decision on the matter over and above the decision of a lower court or lower courts. Now, from that premise, it seems to me that the idea of a specialized judge who knows a particular aspect of the law and does not have a particular age or particular knowledge or experience in another field of law may have an effect of depriving litigants of the many minds that are required in an apex court. I make this proposition to you because it seems to me that you do not have an experience in criminal law, amongst other things. And the tendency is that in the appellate court, we'll have specialized judges in a particular field. And what will happen in practice is that when a matter of, in your case, international trade comes to a court, the other judges are simply going to dump it on the judge who has got a specialized knowledge, and the litigants don't have the benefit of all the other judges exercising their mind in that particular field of law. Isn't that problematic with the application in the sense that you do not have that broad experience, in particular, as you may have confessed, in criminal law?
Well, let me say firstly that I agree with the premise of your question. I do think, as I've already sought to stress, that appellate courts, and particularly the Constitutional Court, needs to draw on many talents to constitute it as a court of authority and one that is widely respected. Where we may part company is that I don't think it follows from the fact that some people appointed to an appellate court have had deeper experiences in some areas than in others, that there's any kind of deference in the appellate court that is shown in terms of how to decide a case and what the right answer to a case is. Obviously, there is some guidance to be had because the experience of someone who has a deep knowledge of one area of the law can be of assistance to colleagues in thinking about the problem. But ultimately, if you have, as you do, independently minded, robust, extremely talented lawyers who constitute an appellate court, then they're applying their minds, and all that having people with some specialized experience in certain areas does is that it can enrich the dialogue that takes place in those areas. So I'm not certain that you get any kind of deference that is shown. It's simply a question of the mix of attributes and how that can enrich the thinking of the court and the way it goes about its business. As to my own experience, I don't believe that there is any candidate who has come before you in the last 2 days who is deeply experienced in every single area of the law.
There is.
Oh, well, then I've mistaken who they are. The fact of the matter is that people have come through to the courts in different ways, and their experience in practice and thereafter on the bench will be varied as to what they've experienced and where their competence lies in respect of particular areas. So I would acknowledge to you that my practice at the bar didn't involve much by way of criminal law. That's absolutely true. It did involve quite significant areas of public law and private law and regulatory law in different permutations. And obviously those are things that I will bring to bear. So I think that's the best way I think I can explain to you how both appellate jurisdictions work and appellate courts work and should work, and my sense as to the kinds of different contributions that different lawyers can make as judges and as appellate judges.
Yes. Focusing on the area of public law and constitutional law for a moment, is it not correct that in the past 25 years, 26 years, since the new constitution or democracy, the advent of democracy in the country was had, the constitutional courts in different eras has produced a body of jurisprudence that it has somewhat stabilized the legal principles applicable in established some concrete principles of constitutionalism from which future courts can look at and draw wisdom from. Now, I want to ask you a question from that premise. That am I correct in saying that is it your view that future constitutional courts will be bound by the principle of stare decisis, doctrine of precedent, in the sense that they will be bound by the decisions that have been made by the courts before it? Or are you of the view that the future constitutional courts have a free hand to depart from the precedent that has already been established by previous courts and develop new principles and deviate from the rules and principles that have been established thus far? I ask this because in the context of this fact, you have appeared in that court in a manner that I would say you have actually dominated appearances in the Constitutional Court. You have had so many. I couldn't count on how many cases you have appeared in that court. And are you of the view that there are any matters that the Constitutional Court have not traversed yet, which remain open questions, which might require some form of development? Or some of the submissions that you have made in your arguments which were not embraced by the previous courts, which you think should be revisited in future courts? I want to hear on those matters.
Yes. Well, let me respond with a few points. The first is that, of course, every court stands on the shoulders of those who've come before. And in the case of the Constitutional Court, we have been enormously fortunate that we have had some giants in that court. The court has generated a jurisprudence of very significant both breadth and depth. I don't think, though, that the question of how our constitutional law develops is one where one says, well, in the first 25 years, you get all the big and important principles settled, and thereafter, courts that follow just fill in the fine details. It's a feature of significant constitutional courts across the world that every single court is faced with remarkably important and often novel points that arise for determination. And this body is facing, in the course of this year, 4-5 appointments to the court, which will have hugely significant impacts upon who will constitute the Constitutional Court for the next 10 years and more. So I think that it's not a question of simply, as it were, taking settled principles and simply applying them in a fine-grained way. And that might be illustrated, for example, in relation to the debates that have opened up around how the Constitution should be understood in relation to the law of contract. What is the role of freedom of contract, which was the value that so dominated pre-constitutional thinking around contract, and how are constitutionally based doctrines of fairness and the like going to figure in the development of contract law? Now, we've had some recent cases from the Constitutional Court, but I don't suppose for a minute that that jurisprudence is finalized and settled at all. In fact, the debate is just opening up, and I suspect we're going to have many, many cases which seek to develop that area of law. And I could talk about others where I think the field is very much open. Let me answer your question on stare decisis. In US law, it is sometimes said that there's something called a super precedent. And then there are apparently other kinds of precedents. And I don't happen to believe in a hierarchy of precedents at all. The Constitutional Court, however, is uniquely positioned because unlike lower courts within the hierarchy that are bound by the decisions of the Constitutional Court, the Constitutional Court can, like every apex court in every legal system that follows stare decisis, consider revision of its decisions. But it does so with enormous care and only usually in the face of clear error. What happens more frequently, I think, if one looks at jurisprudential history, is that very few apex courts announce a complete revision. Usually it is done by stages and degrees, but it has to be recognized that, like every doctrine, stare decisis, at least in the constitutional court, is a constitutional doctrine that goes to the nature of that court and its powers. And that power does include the power to change its mind. It should be exercised very carefully and very cautiously, because people look to the definitive decisions of the Constitutional Court and rely upon them for ordering their affairs. But it is possible. And that's partly why sometimes the threads of authority that you see in concurring judgments and the like have different emphasis. And sometimes one thread turns out to be more important than another.
I wish I could ask you some questions, but I think we've got limits of time.
Indeed.
Unless
Commissioner Mbovu?
if the Chief Justice... Commissioner
Madonsela, at the rate we are going, we are unlikely to interview the next candidate. At the rate we are going.
No,
Commissioner Mbovu?
Thank you, Chief Justice. Good evening.
Good evening.
David. Sorry.
Good evening,
Judge.
Commissioner.
Sorry. Yes, because of time, I'll try, I know you'll be capable of doing what I'm about to ask you. I'm going to fuse my question into one statement, but to which I'd like you to react, and then I'll go to the next one. The first issue is about this. I think there are two issues that have been raised with you where I'd like you to give more clarity. The one is the issue of the South African Jewish Board of Deputies. Now, like Commissioner Sigogo, when I read the evolution of the BLA complaint and your resignation and so on, I was left with the question of, well, if there was nothing wrong with this, then why did you resign? And you've answered that question. My issue with this is that it's more a question of principle, which has to do with the connection. I don't know if you accept, you may or may not accept that there's a connection, at least there's a connection that is made between Zionism and apartheid in many contexts, both as forms of nationalism and so on. You know, I'm sure you're familiar with that debate here. Now, the question really is whether the impression that I have that the Jewish Board of Deputies might not be by definition a Zionist organization. I don't know if it is, but that it's not against Zionism, or there's some affinity or close relationship between the two organizations. And if that is so, if that premise is correct, and you'll tell me if it is not, then my view would be that just as anybody who has any association with apartheid cannot at the same time believe in a constitution that espouses equality, that's obvious. So if that connection is therefore correct, can the same be said about an organization that has some relationship with Zionism being, by definition, inherently irreconcilable with the notion of equality between people? You understand the question?
I understand the question completely, yes. I would simply answer on that score that I never went on to the Jewish Board of Deputies in any understanding that it was connected to Zionism or an advocate for it. The Jewish community, like many communities, is made up of people with radically different views about Israel and the Israeli-Palestinian debate, and indeed whether there is, as you know, a great debate about Zionism and the Israeli state being an agent of something akin to apartheid. I mean, that's a debate.
Yeah.
Because members of the Jewish community are so varied in their views across the board on this point, I would have been very uncomfortable to be in an organization that took some particular position on that issue. And so I was invited to join, as I've said, at a time of some crisis for many communities. And my role, as I understood it, was to see if I could help in any way with the basic role that the Jewish board plays, which is to look after the wealthy of people who've lost sometimes their lives and sometimes their livelihoods, and the connection that it has to other communities where similar problems arise. I saw it as being able to do something for welfare. And I just, as I say, that the Jewish Board of Deputies has a history that goes back. The current board, as I recall, goes back to about 1913 or 1912. But the members that constituted at a national level after the union go back probably a century before, long before Israel was even conceived of as a country. So I think it has a limited focus, and it was with that in mind that I accepted the position that I did.
Okay, thanks. Yeah, well, for the record, yeah, I mean, I'm not one of those people who equate Jewishness per se with Zionism, because I think that in itself is a form of discrimination. It's like stereotyping people, which is unfair. But my focus is really on the organization.
Yes,
I think there's an organizational link between the Jewish Board of the Deputies and their views in general. But anyway, let's put that aside. The second issue that has been raised with you, and I'm sure it's one that you were expecting, particularly because for the new commissioners, you know that when we last had you here, one of the issues we raised was whether you're not coming to get an interview just as a conduit to greater heights, so to speak. And because you have now applied after 3 years of appointment to the Constitutional Court, I think it's only fair that you have to answer that question, whether that doesn't confirm that view or suspicion at that time, and so that can be put to bed. Now, that's tied to the question of, you accept, you know, you were asked about white privilege and you spoke about it in the past. You do accept, I know you do, that those issues, white privilege, apartheid, and racism are not things of the past. They are things that are still with us. Now, given all those the privilege that you had, and it's not through a fault of your own, you are a white male privileged previously and currently person. You have the issue of having been only on the bench for 3 years. You've never acted in the Constitutional Court and so on. Now, and you know this is a competition in the end.
Of course.
If then we have to balance the virtues that the Chief Justice asked you about, which you would bring to the Constitutional Court, versus these other disadvantages. And if I said to you, okay, now I've got you and these other candidates, I really have to choose one, what would you say in your favor to convince me that I should overlook the appearances of these factors weighing against you?
Yes, so as I've already indicated, there are only so many things you can do in a lifetime.
Yeah.
It's a difficult thing to say, well, of course you've got the attribute of X because you've spent a lot of time, for example, sitting on the appellate body of the World Trade Organization, but you haven't yet sat in the Constitutional Court. One could reverse that and say, well, yes, that may be true, but what one is looking for at the end of the day, I think, is not a sort of checklist where you can say, well, you've got to have done that, or if you don't pass through that, if you can't tick that box, then you can't go any further. It's not my understanding that, as I think your question indicates, that's not really the issues that you have before you. I think the issue that you have before you is, let me look at what attributes different candidates have. People, you've heard now for a long time all the things that people can bring to the table before you. You will need and want to think about how are those talents which you've had extensively explored before you, and you will still, perhaps tonight, perhaps tomorrow, how can those talents best be applied to the betterment of the institution, which is the Constitutional Court? I'm afraid I can't give you a metric as to how to do that. I think every candidate has strengths, and every candidate has some things that are, if they're not weaknesses, they're things that they haven't got to for whatever reason. I think at the end of the day, this is about public service. It's about, I will continue to serve in whatever role I can. If it were to be on the Constitutional Court, ultimately, it would be an enormous privilege for me to do so. But if you don't think collectively, ultimately, that that's where I can best be of service, well, that will be your fair consideration. I'm not sure I can take it further than that. There isn't some fine metric where I can say to you, well, it was those last 5 years at the bar that made up for the fact that I didn't have a term in the Constitutional Court. Because when you put those in the balance, the 50 cases that were argued over that period of time weigh more heavily than the term in the... That's not a balance I think anyone can make. One just stands back from it and says, well, let me look at this overall. Let me see how I think this court can be benefited. And then I'm afraid that's your difficult task, not mine.
No, thanks. I appreciate that. And is in part of the answer the fact that we have to look at the package of what we want to achieve in the Constitutional Court, rather than maybe just looking at you as an individual who might have these other disadvantages. In other words, as part of a whole, in a kind of dynamic sense, rather than just, because if you look at individually and you put these factors, then obviously the disadvantages, in my view, would outweigh, particularly compared to the other candidates. Yeah.
I would respectfully, completely agree with you. It's an aggregative question as to harnessing the talents that we have available to make this court itself, to make the court the best court it can possibly be. And as I've said, I think that we must have great ambitions about this court.
Thank you. Thank you, Chief Justice.
Thank you, Commissioner Mpofu. Deputy President.
Thank you, Chief Justice. Good evening, my brother Unterhalter.
Good evening, Deputy President.
Due to the lateness of the hour, I'll be shorter than brevity. I've one observation to make, Judge Unterhalter. During your interview in October 2017, one of the commissioners described you as an eminent counsel. And speaking for myself, your record speaks for itself. Your scholarship, forensic skills, and how well you articulate your views during deliberations are attributes, or some of the attributes that I experienced firsthand in the various cases that I sat together with you in the SCA. Would you care perhaps to comment on that if you so wish?
Yes, thank you, Deputy President. I have had enormous benefit from the time that I've spent in the Supreme Court of Appeal. Admittedly, it's been a time when we have had to operate entirely virtually, and so some of the collegial relationships that one would ordinarily wish for are not capable of realization in the standard way. But I have learned an enormous amount about how appellate work is done. And in that respect, I've found that there has been enormous assistance that I have received, amongst others, from yourself, in showing me the ropes, allowing me to develop within that court. And it is a very demanding court, which pursues its work with great industry, with great acuity, and with very, very speedy results. And all of that is a highly pressured but extremely valuable experience that I have learned an enormous amount from. And it is the way in which colleagues prepare for the cases they hear, the way in which the proceedings are conducted with, for the most part, great economy, but incisiveness in getting to the answers that matter for the purposes of resolving the dispute. And then the interplay between colleagues, firstly in conference in trying to get to where everyone stands on a problem and the robustness of those engagements, but also the discussion that takes place. And one of the signal features I have found is that sometimes the debate is robust, but everyone's desire is to get to a judgment, which is the best possible articulation of the answer that the court believes in. And sometimes there's a dissent, but whatever, it's to try and make sure that that judgment is fashioned out of the assembled abilities that are brought to bear together. And in that, I have learned a great amount, and for which I am enormously grateful.
Thank you. The other two questions I had for you are about why you considered it necessary to resign from the Jewish Board of Deputies, and why, when you had acted in the SCA for 2 terms and you're still there, you chose to apply for a position in the Constitutional Court where there are 2 vacancies as against 5 vacancies at the SCA. I'm satisfied with the answer that you gave when you were in response to a question put, I think, by Commissioner Gogo, and what you said during your introduction. Thank you very much,
Thank you,
Judge Unterhalter. Thanks very much, Chief Justice.
Thank you, Deputy President. Honorable Breitenbach.
Thank you very much, Chief Justice. I'm covered. Thank you.
Thank you. Honorable Nyambi.
Good evening, Judge.
Good evening.
Part of my question were covered by Commissioner Lamula and Commissioner Mpofu. I'll just ask one. We've
Yes.
asked others that are of your age. If we are spoiled for choice in terms of people that are meeting you in terms of qualifications and everything, and what they can bring at that court, then we happen to have the other candidate that can give us the 12 years. But looking at your situation, it's going to be half of that. What will be your comment on that?
Well, I suppose I would say two things. The first of them is that one gets to a certain age and hopefully one has accumulated certain experiences over that period that sometimes have material differences to others who have had less experience in some areas rather than others. So I think that will be for you to assess, which is, yes, I am older than some candidates. The question is, what did I do with the time? And are there things about my experience that would be of value to the court? And that will be for you to determine. There are trade-offs, as in everything in this world, and experience is one of the things in particular areas that can be advantageous, and no two candidates absolutely square up on every attribute that you're looking for. You'll make an assessment. The second is that I think I would have, if 70 is the retirement age, I would have 8 years on the court, perhaps slightly less. I think sometimes there are, as I understand it, but I may be wrong, some extensions of time that can take place for judges such as myself who start late, because I've only been on the bench for just in excess of 3 years. But I'm not certain whether those extensions are possible. I think they may be, in which event I would be able to serve and would be willing to and desiring of serving for as long as I possibly could. I think lastly, to say that the question over is this: over whatever period, whether it's the 8 years or whether it's a longer period, can one make an impact on that court that is going to be of value to the institution? And if you think that I can, I would be honored to try and offer myself for that purpose.
Thank you, Judge. Thank you, CJ.
Thank you, Honorable Nyambi. Commissioner Makelo Debu.
Thank you, CJ, and good evening, Judge.
Good evening.
I see that you have been conferred silk 30 years ago.
I think
Am I right?
I think nearly 30 years ago. In 2002. So not 30, but
Somewhere.
but yes, 20, coming up for 20.
Because I see from the comments of the Bar Council, they actually meant 30 years ago.
I think maybe their arithmetic isn't all it should be.
Yes. So what I want to find out from you, you have been privileged, that we accept, and you have been very active in the Bar Council.
Yes.
And having been in the Legal Practice Council now, and looking back, especially to the advocate's profession, it's one of the professions which is least transformed. And I'm asking myself that, was it not maybe better with your privileged background and access to state work to able to upskill some of the advocates, and how many have you done, have you trained? I'm asking this because we are told that silk don't take pupils. So obviously 20 years of our life, you never took pupils. You know, so for me, you haven't contributed to any transformation of the profession. So what can you convince me? How can you convince me that you have contributed? And why are the demographics of the advocacy profession still so low when, if I have to entrust you with the Constitution, you haven't done much, according to me?
Well, let me see if I can persuade you otherwise, because I took the question of transformation at the bar very seriously, and let me try and indicate how I did so. The first was that I had extensive use of Black counsel and women counsel in the work that I did. And I've done, and if you wish, you can go and look at the reported judgments of mine, which are obviously just a subset of all the work that I did. And you'll see that there are very large numbers of Black counsel and women counsel who figured in the teams of counsel that I worked with over many years that I was a silk. So that's the first thing I would say. The second thing I would say is that I have a very, very long-standing and ongoing commitment to training within the bar, and I maintain that link even now that I'm on the bench. And to my mind, training young advocates and ensuring that they have the best opportunities to flourish within the profession is one of the absolutely key ingredients. It's one of the things that you can see makes an immeasurable difference to the way in which people progress within the profession. The third thing I would say to you is that within the professional relationships that were fostered through having Black juniors and women juniors as part of the cases that I prepared and argued, there was a mentoring role that took place. Everybody needs someone who believes in them and can help them to reach their potential. And I think that was one of the other jobs that I did within the bar. And then lastly, I should say to you that I did, for a period of time, have a leadership position within the group that I was a member of. And in that capacity, together with other members of the group, we made a complete change to the way in which people were admitted to membership in that group. And if you look in that group at those people below 10 years core, you will see how many Black advocates were recruited to that group. And that came about not by chance, it came about by design. And how to support people who came into the group and how to give them a foundation from which to flourish was one of the things that I sought to do. And so I count among people who are both friends and erstwhile close colleagues, many Black practitioners who today have careers of great distinction. And to the extent that I played some part along that way, I think that is what practical transformation is about. That's what I've done personally. As to the profession at large, I agree that there are huge obstacles to people pursuing their careers at the bar. And there are many ways in which that needs to be greatly improved. I could talk about that if you wanted to, but I think the gist of your question was to say, what did you do? And I've tried to give you an answer to that question.
Thank you. A follow-up question. As you know, the Legal Practice Act, one of its mandates is to ensure access to the profession.
Yes.
What will you say if we train advocates as the counsel, as the legal practice counsel? And the challenge that we are having is that the Johannesburg Society of Advocates actually want to exclude the advocates who don't belong to the bar. And for me, the bar is very exclusionary. You can only train about 20, 30, but there are 1,000 kids out there who need to be trained. So what is your view there? Because for me, I mean, this led to the resignation of Advocate Semenya. I mean, for me, it's still a sore, I don't know how to call it, but how do you think we should take this forward? Because obviously the bar councils are refusing to transform. And what influence can you have, because you still have contact with them?
Yeah, I'm not alive to all the debates that have taken place, and so I probably don't have the most nuanced understanding of all of this. Certainly, when I was at the bar, the Johannesburg bar, I think the figures of the number of pupils who came in, and this is just from recollection, but were around perhaps 100 or more, but. I know that Commissioner Mpofu may have more direct information, and there are bars across the country. But I take your point, which is that what the bars will do is that they will take in a more limited number of people and probably give them a more intensive form of training. I don't know whether that's true or not, because I don't know how far the council has the same resources to devote to training over a period of pupillage. So it's possible that the bars are offering more intensive training to a smaller number of people versus a model which would say we can actually get by with perhaps less intensive training for more people. That seems to me to be a policy choice. I take very seriously the fact that people who wish to come to the bar face enormous financial hurdles in doing so. And one of the things that I think needs to be thought through very, very carefully is something that's done in other jurisdictions, which is to help to fund people, particularly over the period of their pupillage and possibly in their first year or two, to try and give them some financial security to make this transition. We don't want the bar to be a place where you have to come from a privileged background in order to get to the bar and then to flourish at the bar. Too many people are disadvantaged in exactly that way. And this is the problem, you lose people of potentially enormous talent and promise because your pool gets too small and it is skewed towards those who can afford to do it. So I entirely understand what you're saying. I think it is, as with all things, a question partly of resources, but partly, as I think you're pointing out, partly of flexibility and a will to change how people get access to the profession and make sure that people who are poor do not face insuperable barriers to being able to come to the bar and flourish at the bar with the kinds of support that I'm talking about. That would seem to me to be a key priority.
Thank you, CJ. I had other questions, but I'll leave it here.
Thank you, Commissioner. Honorable Malema.
Thank you, CJ. Judge, I take it that you support transformation.
I do.
And when you genuinely look at the list of the people who are coming here, who have not had a privilege like you did, and you know that some of them are so well capacitated, they may not have the same education as you, but even with such a poor education that was given to them by the apartheid government, they managed to rise through those difficult situations. And as a supporter of transformation, why don't you just say, you know, guys, let me pull back and allow my brothers and sisters who have worked so hard to be where they are to rise, and perhaps in the second round or so, I may try my luck, because we shouldn't support, and you agree with me, transformation when it doesn't involve us directly. But when it is us who are now involved directly and we stand a chance of going through, we now want to apply the issue of transformation from a theoretical point of view, not because we believe in it since we are involved directly. So I thought someone who support transformation will look at the list we have and say, you know, there are a lot of potentials here. We know we've got that duty, we'll choose the best ourselves. But as an activist and as a supporter of the transformation in the judiciary, you also have a duty to say, thank you very much, I applied, I'm here. But I think that given my background and looking at the list we have here, let me step back and allow my brothers and sisters to emerge. And in that way, you don't have to give this body a difficult job of having to choose between you and those who are less privileged.
You know, I agree entirely that that people who come before you who have had hugely disadvantaged backgrounds and have got to the level of that they have, with the achievements that they have, is astonishingly wonderful to see. I mean, you know, we celebrate people who can achieve things from disadvantage. And you're correct. I have certain achievements, but I certainly had many advantages in getting there. And you could say, well, that should end the debate. And I take your point also that one mustn't be theoretical about transformation. It's you know, it mustn't be it's fine until it affects you, and then it doesn't. Then it's no, you know, then it's put to one side. I agree. I think though that one does have to give some thought, I do, to what transformation means in its different parts. Certainly one part of it is that our courts must look like South Africa, and that's a key feature of what happens, and I think we've made some progress as far as that's concerned. I think the second thing is that transformation is also about harnessing all the talents of our people and making sure that they are represented in, amongst other places, our courts. But I do also think that transformation is about, it's a quality of your mind as to how you think about the world. And I think there are ways in which transformation works through the kind of chemistry of what you want to do together. And that is not just about saying, well, we must necessarily prefer X over Y. It's about saying, I want to constitute, for example, the Constitutional Court in a way where the larger constitutional project of transformation is best likely to be achieved. I can only say to you, as far as that's concerned, that I see this through the lens of service. You may reach the conclusion that ultimately I can best serve in another role, and I will understand that position. And that may mean I should step back in your judgment. But I think there is also a way in which one can think about constituting a court where the attitudes of mind and the desire to make this court something special is one where I could still be of some service. And it's only in that sense that I would ask you to think about my role.
Judge, let me try to persuade you once more. You see, you come in for 3 years. You find senior judges there who have gone through difficult processes for them to be there. If this is not classical case of privilege, then I don't know what it means. You sit there with the beautiful education you got from a privileged point of view. In 3 years' time, you come and pass all these villagers. You come and pass all these people who have gone through poverty, who have gone to be where they are. You pass them and you go to the highest court and still come back to us and say, you know, privilege is not right. We want empowerment, want transformation, and we must still listen to that. When you couldn't on your own, right conscience, say, there are so many people that I found here who are well qualified. They may not have the same education I have because of the background of where we come from. But these guys have been here. These guys have worked hard for them to be here, and they are not as privileged as I am, because we are going to be heavily criticized to choose a white male against a black African female who has gone through the ranks, who has interviewed so well, but she doesn't have what you have for obvious reasons. She's not from all these things that you are speaking about. They come as a result of the privilege you had. She doesn't have all of that. And in your right state of mind, you say, consider all of this and leave her. And you put us in that predicament instead of saying to us, you know what? I appreciate, and now that you have put this to me, my journey to this, at least for now, ends here. I don't think I must still be considered.
Yes. I think there are two points I would make, and I understand the position that you have. The first of them is, as some questions have already been raised, you can't do everything in a lifetime. And, at a certain point you reach an age and there isn't an endless runway before you to say, well, you can come back at another point, because at a certain point you can't. I mean, we all get older, and that's one of the things. So it's not one of these points where if I were coming to you at the age of 50 and saying, I want some preferment now, I could understand that. One can only do so many things in a lifetime. So that's one point. The second is just this: I would never see it really as passing anybody. It's more a question of looking at what I may have to offer in terms of the things that I've done and the things that possibly I can contribute to this court, and saying, some of the candidates who have come before you and have got huge promise and ability will also, in their way and in their time, be able to make the contribution. And you will decide. You might say, well, we want younger candidates who've come from disadvantaged backgrounds to go forward and go forward first, and maybe you will never go forward. And I will appreciate that and understand that that's a judgment that can be made. But I think there's another way of looking at it as well, which is to say, there are some candidates who come, they have some attributes and things to offer. We may want that because transformation is ultimately an inclusive doctrine about how we constitute institutions and how they can operate. And as I've said, we want to have ambitions about the court. We want it to be the crucible of talents. And I would love to give you an easy time in terms of making your choices simpler, but I feel that the nature of your task is the difficult one of trying to work out how that is best done.
Now, Judge, on a different point, do you think that judges being involved in business and having shares in big companies helps to build confidence of the judiciary and enhance its good image? And I'm talking about business and shares.
Yes.
Not bank accounts, like some senior judges were distorting us and not knowing the difference between shares and bank accounts. And coming from senior judges is so disappointing.
Yeah.
And people who are deliberately distorting us and sending us to jail out of deliberate distortion and misinterpretation of what you said. So we're talking shares and business interests, not bank accounts. There's no way a judge can have money in a house. And I would never suggest such a thing as a leader of a political party.
Yes.
So I don't want to go to that level of degeneration. So I'm just asking at the level of shareholding and judges participating in business, does that help to enhance the confidence and the good image of the judiciary?
Yes, I heard the question that you posed to another candidate, and I've been thinking about it since you raised the question. I think firstly, there's a difference between holding shares and participating in a business. I don't think that judges must do judging. They mustn't be running businesses on the side. But that's not answering your main point, which is the fact that judges hold shares a problem? I think the difficulty that we have, and I'm sorry, I won't have a very clear answer for you, is just this, that almost everybody who belongs to a pension fund indirectly owns shares in businesses. Some people own them directly, and some own them through retirement annuities, and some own them by being members of a pension. You get a stake in companies. So I just don't know what the answer is, because I think judges, like everyone, have got an entitlement to save for retirement and have some security in retirement. But I'm wondering whether there's a way we should think more carefully, following what you've said, about, as happens in other jurisdictions sometimes, that they're put in what are called blind trusts. In other words, you say, here are the assets, I will have no connection to them. A trustee is appointed for the period of my office as a judge. They will do with them whatever they do, good, bad, or indifferent. And when I finally retire, I can either take them out of the trust or become involved in it. When I heard your question, that was the first thought that I had, which maybe that would be a separation of a kind that would lead the person in a village saying, well, I don't want them to have indirect interest in shares where maybe that company is then a litigant in court. I don't know if that helps.
I'm happy that there are still judges who hear when we speak. Thank you.
Honorable Moyman.
Thank you, Chief Justice. Just one question from my side, which obviously was prompted by your resignation from the Jewish Board of Deputies. It prompted me to want to get a sense in terms of your views on a two-state solution as a solution to the Palestinian-Israeli conflict. You remember that in 1993, PLO and the Israeli government entered into an agreement to implement the Oslo Accord. So, not much more concerned about your resignation or your membership. That to me is not an issue. The issue is because as a country, in terms of how we relate to our neighbors or to the international global community, our entry point is Africa, and obviously, EU has a position on the conflicts. What's your view on the two-state solution?
Yes, my position on that is that I consider that a two-state solution, although it is now unfortunately one that seems to enjoy much less currency than it did in decades gone by, remains the only solution that I think is both feasible but just in what is a hugely complicated and difficult conflict that exists. So I take the view that there must be a two-state solution, and that people of goodwill should try to fund each other to bring that about in a fair way.
Thank you, Justice. Thank you, Chief Justice.
Thank you, Honorable Moyman. Honorable Klaba.
Thank you very much, Chief Justice. Good evening.
Good evening.
Judge. Thanks. You know, Judge, I felt I should just ask this question because it troubles me. Since we have started the interviews, what troubles me is the length of years that the judges spend in their positions. I mean, for example, you were appointed in 2018, and 3 years later, less than 3 years later, you avail yourself for a promotion for another position. Let me not say a promotion, but for another position. And you're not the first one. I think a number of judges that we have interviewed today are in a similar position. It leaves me with a question. If I knew at the time when I was interviewing this candidate that he would not last for longer than 3 years in the position, would I really appoint him over those who commit that they will stay longer in the position? The question is, what is longer? I consider sitting where I'm sitting 5 years to be a minimum period for a candidate to stay in a position. Why I'm saying this, Judge, is that when we sit here, we appoint people. One, it has to do with the succession plan in the division or in any court. 2, it has to do with strengthening of the court and so on. And then the next person leaves for another position. And then you'll have people coming in and going out, coming in and going out all the time. Does that not affect stability in the division? I don't know, but the heads of the courts happen to be around. How does this not impact negatively on the institution itself? I don't know. You'll be asking on behalf of not yourself, but even the others that have come before us. Thank you so much. Thank you very much, CJ. Thank you so much, Judge.
Thank you, Honorable Kaba. Judge Unterhalter, you want to comment on that?
Well, if I may just comment very, very briefly. I mean, I understand entirely that, rapid turnover of judges who have, an important role to play may not always seem to be in the absolute best interests of the institutions and particular courts. I mean, and your role on the commission is to create the best set of institutions that are possible. That's your mandate. I would just say, as far as my personal position is concerned, that yes, it's true that I've had 3 years on the High Court, with some time spent in the Competition Appeal Court and now in the Supreme Court of Appeal. But I do want to bring to the reckoning the fact that I did spend nearly 8 years. Had I started a judicial career earlier, yes, I might well be able to progress, if progression is possible, in a slower way. But one has less time, and that's just the concrete position that I can draw to your attention. I should just make one last observation, which is that, of course, to some degree, this body has the power to decide whether people revolve through the door, whether they stay where they are, because on some computation, you think that might be the better place for the courts. So in a sense, you have the remedy in your own hands.
No, you are right, Judge. You see, maybe when we meet on our own, we must really look at this. And I wouldn't mind going to an extent of actually saying whoever we appoint will remain in the job at least for a minimum of 5 years, and still utilize him or her in other in other courts on an acting basis.
Yes, I
You know,
understand.
and in that way, you are not losing these fellows' capacity on either side of the on either court. You know, he's in the High Court. You can utilize him in the SCA or Constitutional Court, as it were. No, thank you very much for that. Thank you very much, Chief Justice.
Thank you, thank you very much, Unterhalter, again. I apologize for the delay.
Sorry, Chief Justice, I just have one follow-up before he leaves.
Okay.
Sorry for that.
Yes,
Judge,
Commissioner Notice.
Judge, they have greeted you on my behalf. Just one thing that troubles me. Advocate Gcina Malindi, who was once interviewed after he resigned from the ANC as a member, and his resignation was within a year. In this board, he was asked, it was asked if he cannot take a cool off after this resignation. I'm bringing this because you only resigned from the Jewish board last week or today, I'm not too sure.
Well, a little while ago, yeah.
Yes. Would you accept, if in its wisdom, this body, because it's troubling everybody that you only resign now for purpose of this interview, that at least you are allowed a cool off? It's just that it's something that I will argue, but there's no way that I have to give you that, at least to
No,
hear.
indeed. I think there is an important difference because, as I say, I don't think there is any conflict that arises from the membership that I had of the Jewish Board of Deputies. The only reason, as I've tried to explain, that I've resigned is because there could be some perception in respect of litigation that is done that it would be inappropriate for me to be a member. I could just recuse myself, of course, but it seemed to me that there could be some perception that I shouldn't be on a board which is litigating in courts on certain issues. And I don't, with respect, see that a cooling off is going to achieve anything in this regard, because there is no conflict, and therefore I'm not certain that I see the analogy with Advocate Malindi's position.
Thank you very much, CJ. Though that this Jewish board is a sister organization to Helen Suzman, I know majority of those are part of this.
No, there's no connection between the two.
Thank you, Judge Unterhalter, your excuse, sir.
Thank you, Chief Justice.